Do regulations by New York's Department of Health that limit the amount of seriously mentally ill residents in adult group homes violate the Fair Housing Act? To find out, you have to read Matter of Oceanview Homes for Adults versus Zucker, but it's 11 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of Matter of Oceanview Homes for Adults versus Zucker. The citation for this case is 2025 New York Slip Opinion 00805, published by the New York Court of Appeals on February 13th of 2025. The issue in this case is whether regulations issued by the Department of Health that cap the residency of adult group homes with respect to the seriously mentally ill, is that discriminatory and therefore a violation of the Fair Housing Act? To understand and appreciate the context of this case, the helpful background to know is that in the state of New York, the Department of Health licenses certain facilities which are known as adult homes, which provide long-term care, room, board, housekeeping, personal care, and supervision to 5 or more adults unrelated to the operator, to the owner of the home. And that is classified as it's licensed, it's regulated by the Department of Health as an adult group home. And there's regulations that are promulgated by the Department of Health about how those group homes have to be run. In particular, there's a regulation under 18 NYCRR 487.4, which says that adult homes may not admit residents with serious mental illness if it has a capacity of 80 or more beds and its resident population is over 25% persons with serious mental illness. So if it's over 80 beds, can't have more than 25% of the population of the adult home be a person with serious mental illness. The regulations prohibit those facilities from admitting any persons with serious mental illness until it goes below 25%. And the other thing you have to know is that the Fair Housing Act, which is a federal law under 42 U.S.C. 3601, which was passed in 1988, it prohibits discrimination by direct providers of housing, like landlords and real estate companies, as well as other entities, who discriminate against people who want to get housing on a number of bases, including race, color, religion, sex, national origin, family status, or importantly, in this case, disability. And there's a line of cases that say that discrimination against persons with disabilities may be permissible under the FHAA only if it's narrowly tailored to benefit the protected class. All right. What are the facts in this case? The facts are that in 2016, the Department of Health issued a citation, punished the plaintiff in this case, which is the Oceanview Home for Adults, for admitting persons with serious mental illness in violation of the regulations because it was over the 25% cap. The plaintiff then filed a lawsuit, an Article 78, and a declaratory judgment action, saying that the restriction on the admissions of the serious mental illness residents violates the Fair Housing Act, and therefore it should be struck down. They claim that the regulations discriminate against persons with disabilities, which extends the protections of the Fair Housing Act to New York State. The Supreme Court, the procedural history here is the Supreme Court agreed with the plaintiff and said the law was not narrowly tailored to address the issue of discrimination. It goes to the appellate division, and they reverse. They say it is narrowly tailored. They both agree that it's facially discriminatory because it specifically says you can't allow these people with serious mental illness after a certain amount, but they say it's narrowly tailored to address the issue. It goes to the Court of Appeals, and the Court of Appeals says it's valid. They say the law is okay. Why? They agree that it's facially discriminatory, at least in some sense, and they also agree that the question is whether it's narrowly tailored. But they say that the plaintiffs here failed to establish that the challenge regulations facially discriminate against persons with disabilities, specifically against persons with disabilities, because the regulations are govern how an adult home is managed. They allow people with disabilities. This is what the Court of Appeals says. It allows people with disabilities. In fact, it allows up to 25% of the population to be people with serious mental illness. But the DOH is issuing regulations about how it's run. They issue regulations about how many bathrooms they can have, how many beds they can have, whether the bedrooms have windows and things like that, the width of the door frames. So they're saying the challenge regulations concern the type of institutional settings in which services for people with mental illness may be provided. So they're saying specifically because it doesn't it's not showing any prejudice. It's not trying to hurt people with disabilities. It's trying to theoretically help them. It is narrowly tailored, and the plaintiffs fail. The law is valid because it's regulating the structure of an adult home. It's not punishing or being prejudiced against people with disabilities. That's the case of matter of Oceanview Home for adults versus Zucker. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.